Aaron.
Yeah.
Why didn't you say it the first time I said Aaron?
Because it's pronounced Aaron.
You done messed up, Aaron.
Aaron is here, everyone. Welcome back for more SPTV, where every day is a great day not to be in a cult. A little bit of an update here in one of the many civil lawsuits against Scientology and its evil little dictator, David Miscavige. I know it can be hard to keep track of all the lawsuits. It's a struggle for me sometimes to keep them all straight. And this is just a little update. Not anything unexpected or out of the ordinary, but I like to do a video to document the updates when I can. Now, this is an update to a video that I did 2 weeks ago. I'm going to experiment something. I'm going to experiment with something here for the first time, you guys. The video that I did 2 weeks ago was, oh no, I closed the tab. I closed the tab. Okay, the video that I did 2 weeks ago, 13 days to be precise, was called Update in Trafficking Lawsuit Against Scientology Leader. Now, here's the little thing that I'm going to experiment with right now. There is an AI tool that you can use where you take the link of a YouTube video, you paste the link into the website, and the website gives you a summary of the entire video using AI. So just for fun and just for the hell of it, guys, the video itself is like 20 minutes long, and yet I can read you the summary in less than 60 seconds, and then that will set up the update. Anyway, just having a little bit of fun here with this. Okay, so here's what the website says. Summary of the video. A lawsuit against Scientology leader David Miscavige is being appealed due to a recent Supreme Court decision clarifying arbitration challenges. Highlights of the video. Lawsuit against Scientology leader David Miscavige being appealed after Supreme Court decision. Plaintiffs argue arbitration agreements were signed under duress or fraud. New evidence suggests Scientology arbitrators may not provide fair hearings. Shocker, you guys. I know that's a surprise. New evidence suggests, oh, no, that's the same thing. Plaintiffs seek reconsideration to avoid unjust arbitration process. Supreme Court ruling allows challenges to arbitration agreements on broader grounds. Key insights. The appeal in the lawsuit against Scientology leader David Miscavige underscores the importance of recent legal developments in clarifying arbitration challenges. The argument that arbitration agreements were signed under duress or fraud highlights the complexity of legal proceedings involving Scientology. The lack of fairness in Scientology's arbitration process raises concerns about the protection of individuals' rights within the organization. Seeking reconsideration to avoid an unjust arbitration process emphasizes the need for a fair and impartial legal system. The Supreme Court ruling allowing challenges to arbitration agreements on broader grounds reflects a shift towards ensuring transparency and accountability in legal proceedings. That's incredible. That is a pretty accurate summary of that video. And by the way, this website spit out that summary in seconds. It didn't even have to process. I don't know how this stuff works, guys. It's above my pay grade. I am just along for the ride. Okay, so this is the lawsuit. It is Laura Baxter, Gawain Baxter, and Valeska Paris, all former Scientologists, former Sea Org members, all living in Australia. That's just kind of a coincidence. There's no... Their experience in Scientology, for which they're suing, to the best of my recollection, they all worked on the Free Winds cruise ship. They're not suing for things that happen in Australia. It just so happens they all now live in Australia. The judge had already taken this case and thrown it out of the courts and administratively closed the case and said this matter has to be heard by Scientology's internal arbitration. It has to be heard in accordance with the policies of Scientology's internal arbitration system. Back in May, which by the way is a fraud. It doesn't really exist. It's just something Scientology invented to prevent Scientologists from being able to sue them. Back in May, there was a new Supreme Court decision affecting how arbitration agreements are enforced in cases where there's an argument that the arbitration agreement itself was signed under fraud or duress. Based on the previous Supreme Court ruling, it was generally understood that the court itself wasn't allowed to hear arguments about whether the arbitration agreement was signed under duress. That agreement actually had to be heard by the arbitration panel. In a normal setting, that might perhaps make sense if the arbitration panel, the arbitration committee, the arbitrators are uninterested third parties, or God forbid, retired legal professionals like judges, for example. The problem with this in Scientology is that suing Scientology automatically makes you a suppressive person. A suppressive person is what Scientology calls people who, well, in any way, shape, or form, attack Scientology. Many people who follow Scientology have heard of something called fair game. Fair game is a policy that L. Ron Hubbard created that basically said anyone who is declared a suppressive person is fair game, open season, to be completely attacked and utterly destroyed by Scientology and Scientologists with no repercussions whatsoever. Once upon a time, L. Ron Hubbard, when Scientology was being investigated in Australia, canceled the practice of officially labeling people an enemy or a fair game. But he did not cancel the policies that govern trying to destroy anyone who is declared a suppressive person. It is also a high crime, a suppressive act, potentially punishable by expulsion, for a Scientologist to in any way, shape, or form support or help someone who is declared a suppressive person or considered a suppressive person. This sets up a situation where, by definition, the Scientology arbitration process, it's a fake process, but this idea of Scientology arbitration, where the arbitrators have to be Scientologists in good standing, and the person being subjected to the arbitration process is a suppressive person. It is not possible for an arbitration panel to be fair or to adjudicate in favor of the former Scientologist who tried to sue Scientology. This creates an almost unfathomably stupid situation because the courts are also prohibited by law from interpreting Scientology scripture. Even the so-called scripture, by the way, scripture, I say it with an eye roll or an implied eye roll because Scientologists don't speak that way. Scientologists don't actually use words like scripture. L. Ron Hubbard wrote policies, and they call them policies. But when Scientologists are speaking to reporters, journalists, and judges, they say religious scripture. So the Scientology policies, aka scripture, that Scientology claims govern this religious arbitration process, the judges aren't even allowed to read these policies, read the policy on suppressive persons, read the policies on enemies and fair games, and actually make a legal decision as to whether this is a fair arbitration process. They're completely prohibited from engaging in this level of due diligence in order to make rulings about Scientology. It's maddening. Okay. So when the judge in this case threw this case into arbitration, he admitted that it seemed unconscionable. He was shocked after reviewing the Supreme Court precedent that he actually had to make this decision and seemed embarrassed and sorry that he actually had to make this decision. All right. So 2 months ago, there was a ruling from the Supreme Court in a totally disrelated case that, depending on how you wanted to interpret it, could mean the courts were now allowed to hear the arguments about whether the arbitration agreement was signed under fraud, whether people were induced to sign the arbitration agreement using fraud or duress, and that no longer was that only allowed to be heard by the arbitration panel. And so the attorneys for Laura Baxter, Gawain Baxter, and Valeska Paris went back to the judge and said, Your Honor, based on this Supreme Court decision, we ask that you consider. That's the video that I did 13 days ago. Okay, so what's no surprise is that Scientology has now filed the response and said, liar, liar, pants on fire. That is not what the Supreme Court ruling means. And these people are bad and evil and wasting your time. All right, so let's just take a casual look at the document and see what they had to say. This is Gawain Baxter, Laura Baxter, Valeska Paris versus David Miscavige, Church of Scientology International, Religious Technology Center, the International Association of Scientologist Administrations, the Church of Scientology Flag Service Organization, and the Church of Scientology Flagship Service Organization. We're not going to look through this whole thing. I've already scanned through this thing. I generally know which parts we're going to read, but let's just take a look at it. Defendants collectively hereby submit their joint opposition to plaintiff's motion for reconsideration. The court should summarily deny the frivolous and misguided motion. As defense counsel has informed plaintiff's counsel, there is simply no merit to the position that Suski versus Coinbase constitutes a change in the law on which this court based its decision to grant the motion to compel arbitration. For almost 60 years now, the U.S. Supreme Court precedent has required that fraud, duress, and other challenges to the validity of an agreement that includes an arbitration provision must be heard by the arbitrator and not the court. This well-established doctrine is based on the principle that the arbitration clause is viewed as separate from the underlying contract. Thus, allegations that the main contract is unlawful or unconscionable does not affect the enforceability of the arbitration clause. The parties addressed this very issue in the initial briefs on the motion to compel arbitration, at the November 6, 2022 hearing on the motion to compel arbitration, in the two subsequent rounds of briefing before this court, and then in briefing on plaintiff's unavailing attempt to appeal to the 11th Circuit. Both this court and the 11th Circuit rejected plaintiffs' arguments that this court should hear their duress and fraud challenges to the multiple agreements they signed over more than a decade. Having spent 2 years litigating the applicability of this clear precedent, plaintiffs continue to delay the arbitration that they agreed to over and over again. All right, I'm going to try to fast forward to what Scientology's attorneys claim that the new Supreme Court ruling actually referred to. Okay, this is what Suski decided when the parties agreed to arbitrate a dispute in one contract and then later agree not to arbitrate a dispute in a second contract. The court should decide which of those contracts controls when ruling on a motion to compel arbitration. That is it. This is super interesting. I am endlessly fascinated by the nuance and complexity of court rulings and how to interpret their applicability to other lawsuits. Because on the one hand, the issue that was just clarified by the most recent Supreme Court ruling is slightly different. It's not exactly the same situation as the Baxter Paris lawsuit. But I'll be damned if it isn't close. And I guess this is where it really matters how good your attorneys are, how much research they do, how much homework they do, and how good their arguments are. Because in this, and I don't know whether it's correctly pronounced Suski or Suski, by the way, but let's take a look at this language once again. I actually really love this. Okay. This is what Suski decided. When the parties agree to arbitrate a dispute in one contract and then later agree not to arbitrate a dispute in a second contract, the court should decide which of those contracts controls when ruling on a motion to compel arbitration. Okay, so where these things don't overlap is that the arguments in the Baxter lawsuit is that the arbitration agreement and the contract within which the arbitration clause existed was signed under fraud or duress. In the Suski case, they're not talking about fraud or duress. They're actually talking about conflicting agreements, conflicting contracts with respect to the arbitration clause. That is interesting. And also you have to wonder if, Scientology's attorneys are saying that Baxter's attorneys have misrepresented what the Suski case and the Suski decision was really about. You then have to wonder if it's possible that Scientology's attorneys are in fact the ones misrepresenting what the Suski decision was really all about. I haven't looked at the ruling and I would never try to delve that deeply into it. But anyway, you guys can make up your own minds. Okay, let's see. What else does it say here? Hi, Barb. I'm going to take you off the screen there. Okay, so Scientology's attorneys go on to complain. Rather than address the facts of Suski, plaintiffs use their motion as another vehicle to propagate false claims against defendants in a transparent attempt to bias the court. None of what plaintiffs say about their claims or the utterly irrelevant court-ordered Haney arbitration ongoing in Los Angeles is appropriate for a motion for reconsideration, nor is it remotely truthful. As a condition for joining the Sea organization, Plaintiffs voluntarily committed themselves to be bound by all aspects of the Scientology faith, including religious arbitration of any disputes of or conflicts about the conditions of their Sea Org service. The notion that such covenants were induced by fraud is belied by their repeated assent over decades to such terms. The idea that plaintiffs signed the covenants under duress or served in the Sea Org against their will is conclusively refuted by contemporaneous ship records showing that plaintiffs disembarked and re-embarked over 3,000 times while serving on the Freewinds, and by other extensive documentation of the voluntariness of their commitment. All right. Punctuating the frivolousness of plaintiffs' verifiably false position is their reliance on so-called status reports filed by a lawyer who has been suspended from the California State Bar and declared a vexatious litigant for his actions against Scientology. Ooh, shots fired. Plaintiffs' reliance on the false rantings of an adjudicated vexatious litigant says everything about the lack of merits of their motion and their allegations. Is it normal for filings to be so vitriolic and just dripping with hatred? Is that normal? Or is this unusually pronounced in filings from attorneys representing Scientology? Like, is David Miscavige himself writing these things? Because it seems, as a layman, guys, it seems so unprofessional to be so dripping with spite in these filings. But I don't have enough experience reading filings like this in cases that don't involve Scientology to know if this is normal. You guys, please let me know in the live chat or in the comments section for the replay crew. All right, let's see if there's anything else interesting in here. I forget. I reviewed this a few hours ago. We don't need to read the procedural history. Not necessary. No, thank you. Moving on. What I do find interesting, though, is that ever since this case was thrown into, oh yeah, I see in the live chat someone's asking about my lawyer friend Zach. Yeah, Zach and I mean, look, I'm happy to do a video with Zach about any legal issue. So we'll see if we can circle back and discuss this. In the year or so since this case has been thrown into internal religious arbitration, it's interesting to note that absolutely no progress has been made in that direction. When I first heard that this was going to be thrown into religious arbitration, I wondered whether the plaintiffs were just going to drop it completely or whether they were actually going to undergo the religious arbitration. Because they certainly don't have to. The point in going through the arbitration would be to try and use it as sort of a case study to then go back to the court and show how unbiased and unfair that it was. But I got to tell you, that strategy has not worked out very well so far for other litigants. Let's see. I feel like there was something else in here that I wanted to share with you guys, but I won't spend too much time scrolling. All right. Well, anyway, the argument is that the court should deny the plaintiff's motion for reconsideration because Susky did not overturn the prima paint rule that the arbitration panel and not the court must decide fraud and duress challenges directed to the validity of a contract containing an arbitration provision, even when such challenge would by implication invalidate the arbitration provision. All right. I mean, that's the gist of it. That is the gist of it. There was also another filing in this case by David Miscavige's personal attorneys whining and crying about some stuff, but we don't have to worry about that. Okay, let's see. The lovely Barbara, SPTV Tattoo Warrior, has jumped into the back office and is helping me star some comments. But there's only a few here right now, so let's tackle them. Janet Burns, welcome as a channel member. Ken's channel. Sorry, Davey. No amount of Hawk Tua will fix this one. Any day is a good day for a Hawk Tua reference. Abigail says, does this mean that Valerie Haney can get out of the arbitration hell she is currently going through? Oh, no, most definitely not. This is, there's been, in fact, the Baxter Paris team, legal team, used Valerie Haney's the updates that Valerie Haney's lawyer has been filing in her case as some of the evidence to try to convince Judge Thomas Barber in the Baxter case to reconsider. The Valerie Haney filings with the updates on her arbitration process has tons of evidence that the process is simply not capable of being fair. And that was one of the things that Scientology's attorneys in this case also complained about, that that any updates in Valerie Haney's case were being used to try to make an argument here. And remember, since Valerie Haney is not allowed to have any representation whatsoever in the arbitration proceedings, and because she's not allowed to audio record or record in any way the arbitration proceedings, Scientology can just claim that any information filed by Valerie or her attorney about how her proceedings are going is just pure fiction, just pure lies. Scientology can just say that's all lies, and the court can't even consider it. It's crazy. But no, Abigail, none of this in any way, shape, or form helps Valerie Haney, to the best that I can figure. I eat candy. Anything where Scientology loses in court is a great day. I would agree with you. In this particular case, there's been no loss. Scientology has not lost in any way. But whenever Judge Thomas Barber rules on this motion for reconsideration, they might lose. So I got my fingers crossed for that. Let's see. Dun, 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 dun. Angela Clark. I thought that SPs were forbidden any Scientology. That should include arbitration. It's true. It should. But that would require the courts to read and interpret Scientology policy, and they're not allowed to do that. Oh, I like this question. G Buddy Never In. Did you ever feel like you were part of a religious community? Nope. Never did. Not in my whole, from the age of 4 to 34. I was basically in Scientology from the age of 4 to 34. And as a Scientologist, as a true believing Scientology staff member and Sea Org member, I always cringed. And felt uncomfortable when we had to sort of pretend to be religious-y. When you see Scientologists dressing up in like a priest outfit to do Sunday service, it's like, oh, do we have to do this? Really? Do we have to, I thought we were just supposed to be trying to fool the outsiders. Do we have to pretend to fool each other? Sometimes, when you hear Scientology auditing referred to as pastoral counseling, it's like, really? I don't think so. And as a Scientologist, I very much looked down my nose at religion. Scientology only pretends to be a good faith member of the multi-faith or interfaith community. Scientology very much looks down on members of organized religion, and that was I knew that I was aware of this even when I was a Scientologist. Okay, let's see. Oh no, Nora's in the chat. Hey, how you doing? Good to see you, Nora. Let's see. Kylie, how often do you find yourself thinking about people still in Scientology that you miss? All the time. All the time. There's a lot of good people in Scientology. I just wish more of them would leave. Okay, Kim Wexler's ponytail. In which decade did Scientology grow the most? I think Scientology was growing pretty well between 1950 and 1980. Really, since the late 80s, early 90s, it's been downhill. I'm not sure which one of those decades had more growth than any of those other decades. But from 1950 to the early 80s, Scientology was pretty much expanding. Okay, what is this? Oh, Irrelevant Panda. Has there ever been as many concurrent lawsuits against Scientology as there are now? Well, in my opinion, no. But if someone came out with actual numbers to contradict that, I mean, I would easily be proven wrong on that. But just to the best of my understanding, the answer is no. There's never been as many concurrent lawsuits against Scientology as there are now. All right, everybody, that is all I have on this. Thank you for hanging out with me. This might be the only one I do this evening. It's been a busy day, and it's going to be a busy evening. So thank you for hanging out with me, guys, and I will talk to you soon.
Okay, if you want to see my rock and roll songs, click right on this guitar. And if you want to see a different one of my videos, then you could click right inside here. If you have subscribed or not, subscribe right here. Bye.